Hi, this is Cora Stack here again, Dr. Stack. I wanted to talk about a concept that I find fascinating in constitutional law, and it's called the balance of convenience, and how constitutional questions are never heard or may never be heard based on this fascinating concept. Now, there's a guy that comes on there harassing me the whole time, and he's kind of letting on nothing, so let's give him a challenge. If anybody was to ask me what my favourite theorem was from school, I would have to say I would have to say Pythagoras' theorem. Now that's the square and the hypotenuse is the sum of the squares on the other two sides, and out of that came a conjecture by Fermat, which was that x to the n equals y to the n plus z to the n, where x, y, and z are integers. We'll say positive integers. Was only solvable for n equal to 2, and so that became a conjecture. It's proven, it's true obviously where n equal to 1 and then n equal to 2, and then the question was that 2 for all n greater or equal to 2, and Fermat proved in his margin that it was not true for n greater than 2. So with this, we'll get a counterexample and disprove Fermat's theorem and go to Andrew Wiles and ask him for his proof, and then we'll be delighted with the genius of this fellow, because he'll have disproved Fermat's last theorem, which Andrew Wiles proved took him 7 years, and he went up to a room in Princeton to avoid copyright and plagiarism, as this breach of copyright goes on the whole time, and he was very astute not to let anybody into what he was up to, because of the amount of breach of copyright that goes along. People copying your work and passing it off as their own, and brilliant work and brilliant insights, and etc., etc. So the balance of convenience, how constitutional questions are never heard. What this video explains how a procedural legal test can prevent constitutional rights from ever being examined. Normally, it focuses on the balance of convenience in constitutional litigation. The issue is structural. It's structural. The balance of convenience is used when courts must decide whether to act before a full hearing. What to do, in other words, before a full hearing, where the issue is very, very difficult as deciding what to do or not to do, to be or not to be, says, the great man himself. So Shakespeare. So courts compare the harm of acting now. This is the whole idea of, it's brilliant. This I think is brilliant. The courts compare, they have to kind of do a longitudinal kind of look into the future. What is the harm of acting now vis-a-vis the harm of not acting now? It is commonly used in urgent cases, particularly elections. It is intended to manage temporary risk, not decide constitutional questions permanently. If we're to be very, that's a very good neutral definition, in my opinion. It's intended to manage temporary risk, not decide constitutional questions permanently. But why this test matter in constitutional cases? In constitutional cases, early procedural decisions often determine whether the case will ever be examined properly and fully. If a court decline to intervene, events may proceed, facts may become fixed, remedies may later be said to be impossible. As a result, or moot is often the word that's used, as a result, the constitutional issue may never be decided. What constitutional blind spots are? A constitutional blind spot is a constitutional problem that is not visible at the time decisions are made. Blind spots arise when constitutional arrangements have never previously been tested. Procedure rules block development of facts or arguments, or new combinations of legal rules produce unforeseen effects. These problems usually only become visible only after events occur. How courts can act correctly and still miss problems. Courts are trained to be cautious in constitutional matters. Especially in elections, courts often avoid intervention to preserve stability. This approach follows established legal principles. Even when applied correctly, it can still prevent the discovery of constitutional defects. This is not judicial failure, it's the limitation of the process. Well, it's the consequence. It is 99.99% the result of the limitation of the process. We won't go into any decision about judicial failure here. We'll just say the limitation of the process caused by this decision on balance on convenience, whichever way you go here. But it puts an impossible burden on lay litigants. Courts sometimes see an argument should have been raised earlier. They assume the litigants could foresee which facts would matter, how doctrines would interact, and what constitutional issues would later emerge. Lay litigants in particular cannot reasonably do this. The legal system is expecting foresight that even world experts and Nobel laureates do not have. Procedural correctness versus constitutional discovery. There is a difference between applying a legal test correctly and identifying a previously unknown constitutional problem. A court can be procedurally correct and still miss a constitutional issue. Recognized distinction protects judicial legitimacy while allowing constitutional development. I'll say that again. There is a difference between applying a legal test correctly and identifying a previously unknown constitutional problem. A court can be procedurally correct and still miss a constitutional issue. Recognizing this distinction protects judicial legitimacy while allowing constitutional development. So that's a very important point, I think, here. And I'll say that again. Recognizing this distinction protects judicial legitimacy while allowing constitutional development. And so if you can kind of recognize constitutional blind spot, that, if it's recognized, can actually allow constitutional development. Epistemic harm. Most balance of convenience analysis focus on immediate, tangible